Welcome back to Inside Europe. We are in the heart of the European Parliament in Strasbourg this week, and joining me are two MEPs, Sander Loones and Stephen Woolfe. Now, something which has been in the papers in the UK, certainly a lot this week, is comments made by James Chapman, who's David Davis's, the Brexit Secretary's former Chief of Staff, and George Osborne's former Director of Communications, effectively criticising Theresa May's stance in the Brexit negotiations, saying that it's an absolutist position, and it's making David Davis's job in the negotiations very difficult. Specifically, he says about the European Court of Justice and her very firm stance that the UK can have no involvement in the ECJ after Brexit has taken place. Stephen, obviously you've been campaigning to leave the EU for a long time, a former UKIP member. The ECJ is proving to be an incredibly contentious issue going into these Brexit negotiations. If we look at the discussions we've had so far, particularly to do with issues such as the rights of EU citizens in the UK and expats in the EU.
Yes, I mean, I'm a lawyer. I trained as a lawyer. I watched my own court system as a common law system, very different to that of the European system. And one of my biggest criticisms of the ECJ is that it's not a system made out of lawyers. You don't have to be a lawyer to actually be a judge. You can actually be an appointed politician. You can have lecturers in there. And secondly, it was more of a political project. It was the laws that it would issue would actually be more about trying to create the furtherance of the European ideal. And that is why it's so fundamentally important that when we leave the European Union, that the ECJ should have no part in the laws of the United Kingdom. Just in the same way that we don't allow the US Supreme Court to have an impact on the United Kingdom or the equivalents in Hong Kong or China or India. But the key point is, and this is why I disagree with Chapman on this particular point, is that there will need to be an understanding that Europe regards this as a vital part of their existence and that they want to control their own laws too. So we have to find a way, in the same way that we did with the United States when you're doing trade or people, that we can be compatible with that. But at no cost must we allow the ECJ to have influence over our laws or our people.
Sander, I mean, as a European politician looking at this, understanding the role of the ECJ plays in the European Union, is Theresa May's stance here very difficult? Is it something, you know, how do you see this very firm, we want no involvement with the ECJ, no interference from the ECJ post-Brexit? Do most Europeans think it's reasonable, or do they think it's sort of excessive and is a real barrier to a proper negotiation?
I personally think it's reasonable, but let me first perhaps make a more general remark on Brexit. I'm sad to see you go. We're traditional long and strong allies and friends, so we will continue to be so in the future. Flanders, my region, has very strong economical links with the UK. You're our fourth most important trading partner. 1 in 40 jobs in my region is linked with trade with the UK, which brings us to the word trade. Let us be honest, in my opinion at least, we'll end up with some kind of trade deal between the European Union and the UK, as we have trade deals with other countries in the world, and every trade deal always has some kind of arbitration procedure.
Right.
If there are judicial procedures, I'm a lawyer as well from education, but if there are arbitration or difficulties of differences of opinion, you need some kind of system to resolve it. For CETA, for instance, with Canada, it's the ICS, International Court System. For the EFTA, you have a different kind of system as well, where you can appoint your own judges. Both countries can, both regions can, and come to solutions. I think we'll end up with something like that. It is not logic for the European Court of Justice to have a say on what's happening in the UK.
What's notable then is Theresa May put this to the European leaders when discussing the rights of citizens in the EU, specifically about how the ECJ still can't be involved. There will be an international arbiter, whoever it will be, but it won't be the ECJ. So why are EU leaders, why is the EU Parliament digging their feet in when it comes to the European Court of Justice, specifically to do with the rights of citizens? Because for the UK, you know, for us just reading the papers, it seems like the whole of Europe is very firm on that.
I think because they think it is not only about the rights of citizens. It's also, they think, in our opinion, or in the opinion of a lot of MEPs, it's about the internal market discussion. And unless we we are starting negotiations. Now we're discussing the people, Brits living on the continent, Europeans living in the UK. But that's only one part of the discussion. The more important part is how can we sell goods? How can we trade between between the nation of the UK and the European continent? And for that, the real discussion will be what is the role of the European Court of Justice. And I think a lot of politicians here are anticipating on that discussion, saying that the European Court of Justice is important for the discussions on acquired rights, whereas they want to open discussion on trade.
I mean, obviously the most significant element of particularly relating to the rights of EU citizens and expats in the EU over the ECJ is that if the EU leaders are digging their heels in about who's going to be the arbitrator over their rights, fundamentally we're still no nearer to getting a guarantee of the rights of both parties still. And so, Stephen, do you see it as sort of, irresponsible, a bit reckless for the EU leaders to really be digging their heels in on the issue Theresa May is trying to resolve seemingly, but getting nowhere?
I think it's reckless for any politician, particularly those in the European Union and sometimes those in the UK, who seek to gain political gain by not accepting the realities that has already been accepted by many international countries in trade deals and negotiations. As Sander said, when you've got CETA, and it's now been looked at in Australia and New Zealand trade deals and those of Hong Kong, they're saying we've got an international arbitrator. And also is a recognition that when you're doing trade deals in financial services, for example, if you've got contracts that are actually occurring in the United States, then you know it's the SEC or the US organisation. If you've got Euro bonds, then it would be logical to have the ECJ. If we're dealing with the currencies of China being based out of the UK, then we'd have it as the UK Supreme Court. And people write these into contracts all the time. So recklessness is part of the mantra, sadly, of some politicians here. But thankfully, what I am beginning to see is they're becoming isolated. They're slowly becoming isolated
by other European politicians?
By European politicians who see the sense, as Sander is expressing, the need to have open trade, because many countries need to trade with the UK and the UK needs to trade with Europe, but freely, fairly and sensibly.
Sander, just quick final thoughts.
I think I absolutely agree. The European Union needs a shot of common sense.
Yeah.
For that, I think the UK has a great importance also in collaborating stronger with a couple of countries, more the Nordic countries of the European Union. If you look at Flanders, the Netherlands, Denmark, Finland, even Sweden, these are typically countries that defend the same politics in broad terms as the UK has done in the past. These can be the countries that are your strongest allies in the future as well.
Okay, Sander, Stephen, thank you very much for coming on today.